So my name's Rob. I organize Idea to IPO. We've been doing events in Silicon Valley for many, many years. We hold events multiple times a week from San Jose to San Francisco. I want to highlight two events that are coming up. Later on this week, August 29th, in this room, same speaker, different topic, how to get ready for venture capital funding. In September, one of our showcase events, September 12th, a fireside chat with George Zachary of Charles River Ventures. That's in that's in Palo Alto. So again, check out the details for that event on our website, idea2ipo.com. We launched officially on February 1st, 2010. At that time, we had no members and no events on our calendar. At this stage, we have over 60,000 members among all our meetup groups in the Bay Area. We've completed over 2,100 events. We're the most active, most prolific startup event organization in Silicon Valley, bar none. Thank you. All three of you, thank you. Our mission is to promote entrepreneurship, support entrepreneurs, build community, and provide value in the Silicon Valley startup ecosystem. To that end, we provide content that is practical, actionable, and relevant, stuff that you can actually use to succeed as entrepreneurs. And we believe in building community because Silicon Valley is an aspirational ecosystem and attracts people from all over the world who come here to do great things. Who here is not originally from Silicon Valley or the San Francisco Bay Area? Who here was born and raised in Silicon Valley or the Bay Area? 2 people. Well, let's hear it for the natives. Welcome. So in addition to our content-oriented events, we also have some fun events on Friday nights. The next one is September 20th at TGIF Mixer at the Hyatt Regency Santa Clara, so check that out. You're all invited. We have a mission to provide value at all of our events. We make sure our events are affordable. And if you cannot afford to cover charge for whatever reason, come talk to me and we can work something out. And we make sure we provide a delicious buffet meal at all of our events. Is this a delicious buffet meal? Well, let's hear it for Royce Law Firm for sponsoring that delicious buffet meal. We have many, many partners that help us do what we do. Law firms, venture capital firms, angel investor groups, incubators, accelerators, colleges, universities. Tonight, we're grateful to SVI Hub for hosting us at this beautiful venue. Is this a beautiful venue? Yeah. So let's hear it for SVI Hub and Serdar. Applause.
Thank you so much, Rob. Thanks so much, guys, for joining us. I just want to give you a brief information about SVI Hub. SVI Hub is a co-working space. We offer office solutions to the startups and corporations. We do have different options like flex seating area, dedicated seating, and also private offices. But besides offering office solutions, we are also trying to offer some other resources such as SVI Academy. We offer like trainings, workshops, and some other programs. And some for more mature startup companies, business development services. And accelerator program as well. Also, we started to invest in some of the startup companies. And one of our investors is a multinational corporation. So we do have a corporate innovation arm. And I'd like to briefly inform you about the upcoming events. In October, we do have 1-week program, immersion program, Gateway to Silicon Valley program for startups. And also in October, we are going to host like a few European companies such as Roche, Porsche, Deutsche Autobahn, and some other big corporations. They will come here and spend a few days at SVI Hub to see the Silicon Valley ecosystem. And another event, we are going to do some SVI summits and so on and so forth. So you can just keep watching us, and if you need any information for those services, don't hesitate to keep in touch. And enjoy your evening. Thanks so much.
So our local mission is to support entrepreneurs here in Silicon Valley. Our global mission, though, is to democratize entrepreneurship and innovation all around the world. To that end, we maintain a robust YouTube channel, youtube.com/idea to IPO. Go check it out. We have tons of videos there. We've archived and documented many, many of our events. And this rich, valuable content is available on demand, anytime, anywhere, totally free of charge. Our partner in this endeavor is Tim Jeggers of Jeggers Films, one of the top professional videographers in Silicon Valley. Let's hear it for Tim. Applause.
Thank you, Rob. Thank you, everybody. So I've been doing the video events for Rob for quite a while now. I also do promotional stuff and informational pieces, training, product demos, all kinds of stuff. If you have questions about anything video related, multimedia, photography, that all kind of falls into the realm of what I do. So if you have any questions, I'll be back there. I'll be around after the event also, so feel free to reach out and say hi. Thank you.
We have a relatively small group tonight, so if there's anyone in the audience who has an announcement about something, maybe you're looking for a co-founder, maybe you have a product announcement, maybe you're looking for a CTO, maybe someone in this room wants to talk to you, or maybe you want to talk to them. So is there anyone in the audience who has an announcement about something and would like to leverage this platform? I thought he was raising his hand. Or just combing your hair. Okay, that's right. Are you going once, going twice? No announcement. That's okay. So here's the schedule for the rest of the evening. Our featured speaker will present. He's got an awesome slide deck. Audience members, hold your questions till about 8 p.m. At that point, we're going to open it up to questions. We'll pass the mic around. We'll take questions till 8:30 p.m. At that point, we'll end the formal program. We do have a raffle. We are giving away 3 copies of Roger's book, Dead on Arrival. That's a great name. How to avoid the legal mistakes that could kill your startup. So all you have to do is drop your business card in there. Right now, your chances look pretty good. If you need to get up and use the restrooms or grab any food during the formal program, it's okay. It's a very informal atmosphere. So at this point, I want to introduce our featured speaker tonight. He is one of the top corporate and startup attorneys in Silicon Valley. He's the founder of Royce Law Firm. And actually, I would describe him as an iconic figure in Silicon Valley. He is everywhere. He's at meetups, conferences, the Rosewood, you name it, he's everywhere. So let's give it up for Roger Royce. Applause.
I'm Roger Royce. I'm the founder of the Royce Law Firm. We're a business, corporate, and tax firm based in Menlo Park, offices San Francisco, Los Angeles. This is a talk that I've given many times, especially here to IDEA to IPO. But it never gets old. So thank you for coming out. We're going to talk about some of the legal mistakes. Now, so I speak a lot on this topic and other topics, and I'll just tell you a story today. That happened today. So I actually teach a class at Stanford Continuing Studies on blockchain. And today I got the reviews from the students in, because they get to review me, evaluate me. I get to grade them. They evaluate me. And I had one student, you know, I blame it on us millennials. Us millennials, never mind. I had one student gave me a 0 on a scale of 1 to 5 and said I must be a lousy instructor because she got such a bad grade in my class. I want you to think about that for a minute. A lousy instructor because I didn't teach her well enough to get a good grade. So I hope none of you think that. We're not going to grade you at the end of today, but I promise you that you're going to pick up some very valuable tips here. By the way, I'm not making that up. You can't make this stuff up. So top 10 legal mistakes that startup companies make. I've been doing this for a long time, 35 years now, and I've practiced in a lot of different parts of the country. I've practiced in a lot of different industries. I mean, you name it. I've had clients out in the oil fields of North Dakota, out in the plains, the Great Plains of the Midwest. I was in New York City on Wall Street for 3 years. I worked with, you know, the Wolves of Wall Street. I did Hollywood movie deals. Now I'm in Menlo Park. I do technology startups. I've done international transactions. And, you know, over those 35 years, all these different venues and constituencies, and it's always kind of the same problems. You know, people make the same mistakes, it seems. And with a tech startup, it's just way worse. It's way worse because a lot of the startups, they're a little underfunded to start with, right? So they can't really afford, to have a lot of lawyers running around looking at everything they do. So, and finally, they're very much reliant on some of these issues, especially safeguarding their technology and tying down their contributors. So the mistakes tend to be much more serious. So I'm going to go through my top 10 in no particular order. So number 10 on my list, or number 1 depending on how you count, is using a prior employee's facilities. This is the first question I ask people. People come into my office and sit down, they tell me about their idea and how they want to form a company around it and how they're going to change the world, and that's all fine. But before we can even start, I got to ask them. I say, okay, now about your day job, have you quit that yet? And usually not. I mean, people are sometimes yes, sometimes no. But this thing that you're about to do, this new business you're about to launch, this is one of the few times when you're lucky to be in California, because California has laws that really do protect the mobility of employees. But you got to remember 3 things, okay? And this is the first conversation we're going to have. This thing you're about to do, did you do it at the company's offices? In other words, using the company's facilities. Did you use their computer, right? Or did you use their, their technology, their notepads, their whatever, their machine? Did you use the company facilities? Number 2, did you do it on company time when you're supposed to be working, or playing video games or something? Is that when you worked on this project? And number 3, this thing you want to launch, is that the thing the company hired you to do, right? They hired you to create an app that does this, that, and the other thing. Did you go ahead and create it for yourself instead of for the company? Okay, the answer to all 3 of those questions has to be no. Has to be no. If it's not no, you got a big problem, because it may be that your employer owns your technology or at least has some rights to it. All right, that's what they call a shop right. And they may actually come after you if you try to launch a company using this thing that arguably belongs to them. This idea, this trade secret, this business, this opportunity, or this technology. So that's number 1. If you don't answer no to all 3 of them, we're done. We're dead on arrival, done before we even start, because nobody's going to fund that. So that's it's number 10 on my list, but it's actually a pretty big deal. It's a pretty significant problem. So, be careful about that. And by the way, you have to assume complete transparency, right? I've been on both sides of this issue many times. I just left a meeting before I came here where we sat down and, we got a company with what we think might have been a bad employee, and it took the company a nanosecond to read everything on his computer, right? You just have to assume complete transparency. And they can find anything, especially with some of the AI tools we have now. Okay, so that's my number 10. And it's really important that everything gets documented, right? Everything has to be documented. And it's surprising how little documentation it really takes in order to establish a record. And this is maybe the number 1 biggest and most common mistake that I see companies make. They do business on a handshake, you make a deal. How many of you, by the way, how many entrepreneurs in the group do we have here? Startup entrepreneurs. Any investors? Okay, 1 investor. Okay, we found the investor. Startup entrepreneurs. Okay, so how many of you have co-founders? Yeah, so you really need to get your deal in writing with your co-founder, because until it's in writing, who knows what your intention is and what your co-founder is going to say about this, and how they might view your relationship if you should ever get into a contentious relationship. Not only that, but any employment agreements, any contracts that you have, get it in writing. It's really important to have it in writing. You need that expression of intent. Otherwise, it's your word against theirs, and that just ends you up in court. Right? And anybody with $500 can put you into a court. And I'll tell you what, litigation for a startup company that's another dead on arrival issue. You're kind of done. Nobody wants to fund a company just so they can pay me, to defend you in court. All right. That's poor record keeping. Let's see if I can get the next one to pop up. Hey, what do you know? Vesting. Does everybody know what vesting is? All right, let me explain what vesting is. So, and by the way, every company now with more than one founder, with more than one participant should have vesting. And vesting is the idea that you earn into your ownership, right? That you earn into your shares. So if you've got a couple of co-founders, you really want to be able to tie somebody to the company and not have them be able to walk away from the company very soon after starting with all of their shares. Because if they leave the company needs their shares back to give to somebody else to motivate them. So the way it usually works is that you vest or earn into your shares based on continued service. So for example, a 5-year vesting schedule means that after 1 year, 20% of your shares are vested and they can't be taken away from you. The other 80% can be repurchased by the company at cost or forfeited if you leave the company for any reason. That's vesting. Now, there's a couple of kind of famous examples, although I'm not going to say the names of the company here on film, but there are a couple of companies in San Francisco that have become very popular, very famous, have done very well. Both of them had 2 co-founders. They didn't bother with this vesting stuff. And in both cases, one of the co-founders abandoned the company soon after it was created and left the other co-founder there to go and do all the work. And these are big companies worth hundreds of millions of dollars. So you have 2 companies I know of now where you've got a co-founder who made hundreds of millions of dollars for doing nothing but showing up on day 1 and signing an agreement for stock. Okay, bad result, really bad result. That is by far the exception, by far the exception. Normally that just wouldn't happen, right? There's very few companies that are valuable enough that they can give away half of their common stock and still have enough common stock left over to incentivize the entire team that they need to take the company to a successful financing and exit. Very few. In fact, I've seen just the opposite. Usually, it's like, look, you've got too many people in this company that have vested shares. There's not enough shares left over to incentivize everybody, and the investors will walk away. So this vesting is really important. Now, let me ask you a question. How long do you think a founder should vest in their shares? Anybody? What do you think is standard in this valley? We got 5 years. I hear someone say 4 years. Anybody say 3? No one says 3? Steve says 3. What's that?
4 or 5.
So 3 or 4 is what I usually see. And I represent almost always companies, so I usually tend to be a little more founder friendly, with the vesting schedule. So I usually do 3, although 4 is probably really common. That's what you commonly see. If the investors come in, they're going to want to see 4 usually. But I'll start with 3. And my theory is like it's preemptive vesting. It's reasonable enough that you might not have to argue about it with your investor. If you did 2, that's on the table for renegotiation. If you said 5, you probably gave up more than you have to. So I'll say 3, and maybe they'll let you go, maybe not, because they got to pick their battles. And I like to be a little more founder favorable. By the way, your investor, when they come in, these days, they usually just reset that clock, right? They make you start vesting all over again. I see that more often than not. So in a way, you're not protecting yourself or protecting the company vis-a-vis the investor. You're sort of protecting the founders from each other. What happens before the investor gets into play. How about non-founders? How about just all the people in your option plan, all the consultants and employees that you had to give stock to? What do you think for them? 3, 4, 5? 5. 5 is pretty common. 4, again, is probably the most common, for those sorts of people. And then finally, there are advisors. Do you know what I mean by advisors? So your company is going to want to have, will oftentimes, if not always, have a team of advisors. Now, advisors are not like directors and they're not like consultants, right? Directors are responsible for the overall management of the business. Consultants are responsible for providing you with a particular result. Maybe they're building a tool for you. Advisors are there for their expertise on a very specific area. You can have technical advisors. You can have financial advisors. right? And they get compensated usually in equity, almost always in equity. Stock options if you have an option plan, stock if you don't. So the advisors are going to get their equity, in exchange for this service that they're providing. But keep in mind, it's very specific and very targeted. For example, if you have a fintech company, you might want to have an advisor that knows something about the financial services industry if you don't, or you might have an advisor that can get you into the markets. Well, that stock has to vest too, right? How long should an advisor vest? 10 years. It's usually 2 years. Usually 2. And the reason why is because they're there for a very targeted purpose, right? So they better be able to accomplish it in 2 years. The other thing that's different about advisors is, unlike your consultants and your founders maybe and your employees, when an acquirer comes along, when your buyer comes along, they don't need the advisors, right? They don't need it. Everybody knows that. That they have all that expertise. They don't need people to help you get to an exit anymore. They are the exit. So they're going to terminate the advisor, at close. So advisors typically, their stock will accelerate. Their vesting will accelerate. You know what I mean by accelerate? It means all the unvested shares become vested at close. So it can't be repurchased at cost anymore. Okay, so they get the full benefit of their bargain. That's really the only time you're going to do that. Okay, we used to see founders ask for that, for themselves, saying, well, I got all this vesting, but what happens if, we sell the company and we trade the stock in my little company for stock in a big company? I shouldn't have to have vesting on stock in that big public company. I should be fully vested so I can go sell it and cash out. That was the argument. That's just not market. I'll just tell you, it's just not market anymore. That's what we call a single trigger. Another single trigger is the founder might say, hey, you know what? There's 3 of us in this company. The 2 of you might get together and gang up on me and kick me out for no good reason, right? And if that happens, that's not fair. If you take all my stock away, I should fully vest on a termination without cause. That's another single trigger. It's just not market. You don't see that anymore in this valley. What you do see, however, if you know to negotiate this into your deal, is what they call a double trigger. And that's if both of those things happen in close proximity to each other, then you should get your full or at least some additional vesting. Okay? You know what I mean by that? So the deal ought to be, big company comes along, Microsoft is going to do a stock for stock. Actually, Microsoft doesn't acquire properties that way, but let's assume they do. They're going to do it, Google does. Google's going to do a stock for stock deal with us, right? If say I'm the CFO of the company, well, Google doesn't need another CFO. So they're probably going to terminate me soon after this deal. Well, if I get terminated within 6 months of this change of control, this sale to big company, then that's totally not my fault. And I've done everything that I could to, serve my role in this company, and I should get some accelerated vesting. You shouldn't be able to just dump and take back my non-vested shares, right? That's a double trigger, those 2 things. And that's what that protects against. That's the compromise. That's what we typically do, if you know enough to ask for it and negotiate it. On that point, by the way, it's here's another sort of that's Hollywood sort of point. Very few founders have their own legal counsel when they go into these deals. And the law governing lawyers has changed in the last 2 years now, since 2017. And lawyers are just now starting to figure this out, that it's awfully hard to represent a company and not have to look out for the interests of the founders. So your lawyer will probably, if you have company counsel, how many of you have a lawyer? Okay. Company lawyer. Okay. How many of you ever seen a lawyer? Okay, 1. So your lawyer's probably going to tell you, look, I want to be very clear here. Represent the company. Don't represent you. You're not my problem. Don't count on me, right? Because there's a little bit of a conflict, especially when you got an employment contract with the company. Right? You can't serve 2 masters. Whose interests are they? So you're going to have to be careful, even if they don't tell you that, and be careful about your own interest in this and looking after yourself. And this is one of those areas where if you don't ask for that double trigger acceleration, and if you don't, pay attention to the vesting schedule when the VCs come in, you might not get a good deal. You might not get the best deal you could have gotten. So keep that in mind. I'm seeing more and more companies now consider getting their own counsel when they, for really hot companies. And at some point, you certainly will. But again, that's Hollywood. Startup land, I see companies go all the way to the M&A, and never have individual counsel. And then we get to the exit and they're negotiating their employment agreement, their carve out or their big bonus that they're getting at exit, and they still push back on getting their own lawyers. Don't do that. Don't do that. You need your own counsel, especially at that point. Final thing about vesting. Oh, geez. Final thing about vesting is that there's this thing called milestone or performance vesting. And with milestone vesting, that's something that you always want your advisors to do. What do I mean by a milestone? Well, keep in mind, advisors are not like employees or consultants. They don't come just showing up at the office every day so you can measure, how long they've been there, how many hours, etc. How do you know that they've done their job? Well, by putting in place milestones and performance metrics, because they might disappear for 2 years and you don't know if they're helping you or not. So advisors always want them to have milestones. Look, I hired you to get me into the market. You got to give me 12 leads, or you got to put 2 hours a week in, or you have to close this many sales or make this many introductions. Whatever it is, milestones and metrics, really important for advisors. Okay, number 4 on my list here, inadequate tax preparation. So we could talk for an hour about choice of entity. Let me talk about a few tax things, because I am primarily a tax lawyer. That's how I started out. So you're kind of going to have to suffer with that particular personality flaw of mine. So let me talk about the first one, is choice of entity. What is the most common type of entity? C corporation, S corporation, or limited liability company do you think startups choose? C. Yeah, C corp, by far. What is the worst thing you can be as a taxpayer? A C corp. Okay, why is that? Why is that? But that's what makes it, that's right, double taxation. I have this conversation with lawyers from outside of this valley all the time. It's painful because they don't understand why it's got to be a C corp. All right, so C corp is double tax. What that means is that corporation makes $100. It pays $21 of that 100 to the federal government, pays another $9 to the state government, distributes the remaining $69 out, and then the shareholders, they get taxed again when they get that 69. By the time they're done, they've paid more than $50 in tax. Okay, it's 30 times 70, around $50. Okay, so that's not a very good result. With an S corporation, which is just a corporation that makes an election to be taxed in this particular way, or a limited liability company, those are what we call pass-through entities. Those entities have one level of tax at the owner level, no tax at the entity level. So you only have one level instead of 2 levels of tax, right? It's much more efficient. So having said that, why are all the startup companies C corps? And you go outside this valley, you won't find that many C corps. You'll find way more S corps and LLCs, way more in this country, by far. So why is everybody formed as a C corp? The VCs like it. Okay, that's the biggest reason. So let's pause on that for a minute. The VCs like it, and you're absolutely right. The venture funds like it because, first of all, a VC can't invest in a S corporation. It would terminate the S election. Number 2, they won't invest in a limited liability company because their organizational documents will prohibit them from doing so. And we could go into why that is if you really want to. But for now, just suffice it to say they won't invest in an LLC. They're going to make you be a C corporation. So what kind of company is suitable for a VC? If you've been out here to listen to Gary Jenks, you've probably heard him talk about how VCs demand explosive growth in their companies. So if you're a startup company that's either going to have explosive growth or nothing, then you're a candidate for the VC. You might as well be a C corporation, right? If you have to scale, right? If you've got an app, so you're either going to scale or you're not going to, it's all or nothing. It's what I call go big or go home. If you're one of those companies, you might as well start as a C corporation. That's most of my clients. Most of my clients are in that category. On the other hand, if you're a company that you run a really nice yogurt shop or whatever, you're going to make some ongoing income, you're going to be able to pay yourself a salary and not much more. That's what we call a lifestyle business. You're never going to see a VC, unless they walk into your store. That one ought to be an S Corp or an LLC. That ought to be a pass-through, right? There's no reason to give up the extra taxes. Now, unfortunately or fortunately, a lot of companies, they're kind of in the middle. They're not really sure what they should be, right? Because they can make money. They can get to EBITDA if they want to. And in fact, they can find some angels that are just happy taking a lower return and a lower risk. On the other hand, they might hit a home run. They might hit it out of the park. They might scale, right? You're just not sure. What do you think those companies ought to do? Maybe an S Corp. Tell you what I do is LLCs. So why do I do that? An LLC gives you both about the best of both worlds, right? You get the pass-through tax treatment, and you get losses, by the way, passing through to the shareholders, or the members rather. But if it turns out that you do get a VC interested in you because you are able to scale, you can convert that to a C Corp. Now, why is that better than converting an S Corp to a C Corp in that scenario? Okay, and this might be the most important thing you hear all night. Qualified small business stock. Does everyone know what that is? So when you're an investor, or even you as a founder, when you buy stock in a company or you own stock in a company, if that company is a qualified small business, and that's defined as having less than $50 million of gross assets at the time of the issuance, and it can't be a services business, and a few other things, but most companies would qualify. If you own that qualified small business stock for 5 years and you sell it, you don't have to pay federal tax on any of the gain from the sale of that company up to the greater of $10 million or 10 times your cost. So for most companies, it's $10 million. That's a huge benefit. That is a huge giveaway, right? It's a big one. So I think it's really important to check in and think about, think about the tax issues. Where was I? To think about these tax issues. So that's why a C Corp is not so bad. So I can convert my LLC to an S Corp or to a C Corp, and that stock I get in a C Corp is going to be qualified small business stock. An S Corp, on the other hand, when I convert it to a C Corp, I don't issue any new stock, right? Usually, there's some really cool, interesting ways we can do that, but you don't want to know right now. But for the most part, you're just going to terminate your S election, no new stock gets issued, you don't get that qualified small business stock benefit. I've been through that scenario many times. So I like doing the LLC. Now the downside, just so you know before you rush out and form an LLC, is that if you know you're going to be a C Corp, you've doubled your cost, right? Because you paid for an LLC, limited liability company, then you've paid for the later C Corp. So you've doubled your cost, your legal cost. And number two, the conversion can be complicated. Okay? It can be complicated. And it might be taxable. Okay? It might be if you're not careful. So it's complicated, it's messy, it's sticky. So just keep in mind, it's in tax, the more complexity you can live with, the better result you generally get. So that's just one. I don't want to spend all night talking about tax, so I'm going to move on. But that's one that it's surprising how little thought goes into that decision by companies before they pull the trigger. Labor laws. Yeah, this is another big one. By the way, I'm going to circle back on tax if we have time at the end, because there is a scenario where you'd really love to have an S Corp. Okay. But I want to get through all of these. So let me move on. Labor laws. Steve and I, who's in the back here at the Royce Law Firm, we have an employment law partner who does nothing but labor law, and she just hates startups because she knows by definition they are not going to be compliant here in California. I mean, the rules here are just so Byzantine and overreaching, you know, it's almost impossible for any company to fully comply. And by the way, they're about to get worse. Okay, I'll tell you about that in a minute. But so let me talk through the biggest mistakes with labor laws. Number one, our wage and hour law. They are tough to comply with, right? You got to give people meal breaks, got to give them rest breaks, got to track their hours, you know. So if you have employees, you know, odds are, you know, you're probably messing that up somehow because it's hard to comply with unless you got a full-time HR department. And it can be something as simple and as ridiculous as, you know, they check their email on a weekend and don't charge you for that time, okay? You've just violated the labor laws. And by the way, you did nothing. You did nothing except let them get into your email, right? A worse one that we see over and over again is people who will work and not clock their time. I used to have a paralegal who was very inefficient. In order to cover up for that, she'd come in at night and do all the work that I thought she was doing during the day. And she felt like she was doing me the biggest favor in the world, you know, because she wasn't, you know, she wasn't recording it. She was just doing the work. So, you know, all her work was getting done in the 8 hours a day I wanted her to be there. And one day I happened to be there late at night and I saw her and I said, "What are you doing here?" And I uncovered the whole thing. And I had to go back and figure out her hours for the last year and pay her for all that time. Because I was in violation of the labor laws because she's working and I wasn't paying her for it. So you can tell it's that ridiculous. And had there been any sort of, you know, claim, you know, I would have lost. I'd have been toast. Okay, so that's one, wage and hour. The other place where this becomes a problem, like California's laws are getting very, very tough. Every company has to have harassment training now. I don't know if you knew that or not. You don't have to have 50 employees anymore. You know, it's a problem because very few companies know about this, especially startups. There's a whole list of things that companies need to do. But kind of the big one that I want to talk about is what's going on in the gig economy. How many of you have sharing apps, gig economy apps? A few of you, okay? Yeah, like Uber, like Airbnb. What's another example? Any platform, like HomeJoy. Have you heard of HomeJoy? You know why you haven't heard of them? They took $10 million of venture capital. They were a platform where you could go online and you could find a housekeeper. You haven't heard of them because they went out of business. One class action. They took $10 million and they got sued almost very soon after they closed, and poof, it was gone like that, and they were done. So the VCs lost everything. Class action lawsuit because they were misclassifying their employees. In other words, they treated all of the housekeepers that were going onto the app and using the app to find a customer, you know, they treated all those people as employees of the platform company that had the app. And that company was not withholding, it was not paying overtime, you know, was not tracking weight, you know, meal breaks, all that stuff. Gone, done, you know. So that was a real wake-up call in this massive misclassification issue. And about a year ago, a big California Supreme Court case came down called Dynamex, which very much expanded the definition of employee for purposes of wage and hour laws. And right now, sitting on Gavin Newsom's desk is the most expansive, most ridiculous classification bill in any state. In fact, Elizabeth Warren came out here and campaigned on that bill, you know, because it's a huge expansion of current law, and it will make almost every gig economy person an employee for all purposes, including tax. Personally, I think that's the end of the sharing economy in California if that passes. It'll be just like the bit license was the end of the Bitcoin industry in New York City or New York State when that passed. So now everybody has been lobbying in Sacramento, so that there's an exception for lawyers from the bill. There's an exception for plumbers. There's an exception for real estate. There's an exception for almost everybody, except you, right? Technology startups. So it'll be the end of that industry. Silicon Valley will turn into Detroit if that passes. That's my prediction. So be careful. Misclassification is a real sleeper. It's a really difficult issue. And you misclassify employees, it could be the end of your company before you even start.
In that case, can the company move to another state?
Yes, that's exactly what they're doing. We hosted in my law firm 3 weeks ago. I hosted a breakfast for a congressman from Texas. His district is Houston and Austin, Mike McCall. And he mentioned to me, he said, we have 100 Californians a day, 100 a day moving into my district in Texas, right? And if you drive through those communities, you're going to see California company after California company, all up and down the road. Right? Yeah, that's exactly what companies are doing. They're fleeing the state like you wouldn't believe. And it's about to get worse if that bill passes. So you know. Okay, let's shift gears. We've got Steve Colby, our patent lawyer here. Heads our patent and intellectual property group at the Royce Law Firm. So I'm going to talk a little bit about intellectual property. Failing to protect IP. Not one of the big mistakes companies make. Another one that's really going to hurt you. There's this thing called an invention assignment. You need everybody who touches your IP to sign that invention assignment, okay? Super important, right? And what that invention assignment does, it basically says, look, I've worked on this for you, the company, but I'm not going to claim any ownership rights in it. I'm going to give you, the company, all the ownership to this code that I wrote or this design that I came up with, or this invention or idea that I helped you with. If you, the company, don't have that, from your contractors and consultants, you can't claim to have exclusive rights to the IP, because that means that the person who developed the code, they arguably may have a non-exclusive right to go use it in their own business, okay? And arguably may have is enough, to create real problems for you. So, and when people say ownership of IP, ownership of intellectual property, you know what they mean by that? They don't necessarily mean that you have the right to use something. They mean you have the right to keep other people from using it. That's what ownership is. If I own this podium here, it means I have the right to keep you from using it. That's a right in intellectual property. And if somebody else can use the IP, you can't claim to have ownership. And your investors are going to hate that, because they don't want to put money into you when there's a competitor right next door doing the exact same thing using your tech. So these invention assignments are really important. And the mistakes people make with them are three. Number one, they don't get them at all. And if you've gone and incorporated on one of the online incorporation sites that promises you everything, including a bank account, odds are you may have missed this. You may have screwed this up. Number two, they get it, but the wording is messed up. There's still a form floating around Silicon Valley, where the wording promises to assign, but does not assign. And that might sound like, subtle lawyer doublespeak, but trust me, there's a case here in California where somebody signed an agreement that says, I promise to assign, and the court said, that's not an assignment, that's a promise to assign in the future. So you, Mr. Company, you don't own that IP because he went and assigned it to someone else, in the meantime. And three, and this is a little bit fuzzier, but these agreements always say, you assign to us everything that you create in the scope of performance, et cetera, except the stuff listed on the schedule. And people don't pay attention to the schedule, right? So if you got some proprietary tools that you use in your business, you want to list those and say, look, this stuff is mine. You put it on a piece of paper and you sign it. All this other stuff I'm developing for you, that's yours, or all this other stuff I'm working on, but this is mine. If you don't do that, it's bad for everybody. It's bad for the company because it looks like nobody really understood what they were signing. And if you don't think a lawyer will make that claim, then, I got some complaints you should read. And it's bad for the individual because they didn't go to the trouble to identify, what was theirs, and they might have inadvertently assigned it. Because you got stuff that's personal to you. you've got tools if you're a consultant that follow you around. So again, like tax, a little bit of thought ought to be put into this before you just sign those documents. That's failing to protect intellectual property, the biggest example. Trademarks. People don't pay enough attention to trademarks, and I don't know why, because it is just way more important. When we talk about IP and intellectual property, people are oftentimes thinking patents. And yes, patents are important, right? But that's not everything. That's not the only intellectual property your company has. It also has all the rights and the goodwill and the value, the brand value that's wrapped up in your name, your mark, and your logo. Now I want you to think about the life of your company, your technology company. You're going to start building a product. You're going to start selling that product into the market. People are going to start recognizing the name, right? And there's a million other competitors doing the same thing, even though I know you're going to tell the VCs there's no competitors. You know, I know there are, right? And the reason they're coming to your product and not going to the other one is because of that mark and that name, right? So when you get to the point where you're going to exit and sell the company, what are you really selling? It's not like you got a bunch of inventory laying around, not like you got supplies or equipment or machines or anything like that. You've got goodwill. You've got some technology. You've got a cool app, but you got this huge user base. You got all these eyeballs, right? Remember the Snapchat offering? Like $1,000 a user valuation from a few years ago? Well, think about that. What happens if Snapchat all of a sudden didn't have the right to use their name and their logo? What do you think they would be worth, right? That's almost every company I deal with. There's so much value wrapped up in that name because that's what guarantees customers are going to keep coming back again and again, and that's what you're oftentimes selling. Now, the nightmare scenario is when you get into negotiations to sell the company, you sign that letter of intent, you sign that definitive agreement, the deal gets announced, all of a sudden the world knows how valuable you are, and then you get that cease and desist letter from a lawyer saying, we've just now discovered that you've been infringing on our trademark all these years. And you either have to stop, which means your deal craters, or you have to pay us an exorbitant sum. And by the way, you got 30 days to do it because we know you got a 30-day window to close this deal. It's not a good place to be in. It's not good to have a gun to your head. So that's the mistake. And it makes my top 10 list because I see it over and over and over again, you know, no matter how much I give this talk. And it's really it's not a happy thing. So how do you protect yourself from that? Three things. So number one, obviously, I know how to use Google, right? You do too. Just make sure before you even think about using the name that it's not obviously out there. You can't find it on Google. That'll help. That'll get rid of 90% of the bad ones, at least. Number two, the name and logo, you might not have found it on Google, so do a search with the Patent and Trademark Office. We call it a knockout search. And number three, do a federal registration. Protect the mark. Protect it, all right? Get that federal registration. It's important enough that it's something you want to do. You don't want it to take a back seat. All righty. 409A. So does everyone know what 409A is? Okay. Oh, a couple of you do. So in 2005, it was. Remember Enron? Probably not. Anyway, so we got 409A. It keeps companies from playing games with deferred compensation and basically taking money out of the company and rewarding people without them being taxed on it immediately. It just puts it in an account and they take it when they feel like it. So 409A taxes deferred compensation. So if I earn money in this year, but I don't receive it until next year and I'm an employee, I have to either comply with the rules of 409A or I'm going to be taxed in this year because that's the year I earned it. Now, why is this a big problem for startups? And it is a huge problem for startups. And there's two examples. Number one is stock options. Every startup, you use equity. You don't have a lot of cash, you got a lot of stock. You use stock to compensate people, usually in the form of stock options, right? The 409A rules say that options have to be granted at fair market value, right? That means an option is a right to buy stock at a certain price. So my stock's worth at 10 cents a share today. I'm not going to make you pay me 10 cents. I'll give you a right to buy it for 10 cents, for the next 5 years, right? So you don't come out of pocket at all. You just sit there and wait for the stock to go up in value. When it hits $1, or when you sell the company, maybe then you'll pay me 10 cents and get your dollar's worth of stock. It's a great deal, right? It's a great deal. Silicon Valley's got such a great thing going here. That works fine as long as that strike price, that exercise price, is fair market value at the time of grant, which in my example was 10 cents. And that you have a professional valuation to support it. Okay, if you don't have that professional valuation, we don't know if it really was 10 cents or not. Now, I know that there is this idea floating around out there in the ether from before 2005, when people didn't have this requirement, that you don't have to have a valuation for an option. You just have to make a really good guess, right? Or you have to be 10% of the preferred stock price. Or you have to have the good faith determination of the board. Those were all the rules back when, what was hot when, I don't know, when I was learning to program my VCR, right? Those were all the rules 20 years ago. Now the rules are much different, right? Now the rules are you have to have that professional valuation. And if you don't, you can't trust those options. And now I know there's a thought going around that's saying in the Valley that, gee, the company is, and I've heard valuation people say this, your company's so young, it's so new, we can't value it, nobody should make us do that. Let's just guess a high number that no one will ever challenge, right? The IRS, the Internal Revenue Service, will never challenge that number. Let's just use that number instead of paying a couple $1,000s for a valuation. And that works great until it doesn't, because it's not the IRS that I'm worried about. It's your acquirer who's going to hire someone like Deloitte to come in and take a look at it and are going to advise the buying company that, you can assume those options, but that's a risk. Do you really want that risk? Because you're the buyer. You got all the leverage. And I've been through this over and over again where the company, saved $2,000 on the front end, and on the back end, the buyer said, you know what? Cancel all those options. We don't want them. You go back and you tell all your engineers that you gave stock options to that you made a mistake and they no longer have options in the company. If you want to sell this company, that's what you have to do. I've seen that over and over again. So don't make that mistake. Get the valuation or don't do options. Just sell stock. But options are a problem. The second place is with regard to deferred comp. So I know a lot of you with your own startup companies, you're not taking salary, right? You're working really hard. You're there on nights. You're there on weekends, okay? You're putting a lot of effort into it, but there's no money to pay you. So you might get this idea that, you know what? I should get like my back pay when we get funded. I should get this big bonus. So I'm going to start accruing my salary, right? I'm going to defer it. So when the VC comes in, when they invest, the first money out is going to pay me for the 3 years that I've been living on top ramen, right? Well, number one, you're going to be surprised what the VC will tell you about that. They're going to say, no, we're not going to do that. But every once in a while they do. Every once in a while they say, you're a hot enough company, we'll let you take some money off the table as back pay. But number two, again, there's a tax issue. That's a deferral of compensation, has to comply with the law. And it's very complex to make that work. I won't go into the details, but trust me, if you're going to do that, you absolutely have to have a tax lawyer because it's hard to make that work. It's not impossible, but it's hard. If you just do what I've seen companies do, just put that entry on your financial statements, deferred comp, you're going to create a big penalty for yourself and a problem for the company. Okay. Gotta hurry up, I'm running out of time. Failure to comply with the securities laws. This one is a way bigger problem now than it used to be because it's so easy not to comply. Almost anybody can go on some sketchy website, and list their company and mess up all the offering rules. Don't do that. You should not sell any stock or security without using a lawyer. Where this comes up most often these days is with regard to tokens. Everyone know what I mean by tokens? Digital assets. where people say, look, we're going to sell this digital asset, this token, this cryptocurrency. We're going to raise money that way. It's non-dilutive. And oh yeah, it's got this utility or this use. You can burn it. You can trade it for software. So therefore, not a security, right? Yeah, wrong. That's where people are getting in real trouble, is selling tokens and not treating them as securities. But it comes up in a lot of other places too. Comes up in selling stock to your friends and family. I have two clients. What's that?
Yeah, an example I would do today. I'm sorry, but introductions. Somebody saying, yes, I have a couple of investors for you. And this was a very sophisticated person, so we knew what not to do. But last week it was somebody who said, oh, pay me 1% or whatever, 3% of what I raised. And I've got cousin Joe here who's going to put money into it. And so I see actually more and more of this broker-dealer issue.
Yeah, there's a broker-dealer issue hidden in this. So let's pause on that. I think you all know about the sale of unregistered securities. Bad idea, don't do it. What Steve is talking about, which comes up a lot now, is using unregistered finders or unregistered broker-dealers. Broker-dealers, anyone who helps you find money for a fee, like I'll find you money, just pay me 4% of what I come up for you, they are a broker-dealer. They have to be registered as a broker-dealer. If they're not, the investor has a right of rescission. They can get their money back, and the broker-dealer isn't entitled to a fee. So be careful about that. Now, California has what they call a finder's law, so you can use a California finder for that purpose if they keep everything entirely in-state, entirely intrastate. So you don't solicit money out of state, you don't solicit money for an out-of-state company. Very narrow exception. The securities laws are tricky, they're complex, they're changing, and you can get in real trouble with securities laws. I have two former clients that are currently sitting in jail right now in prison for violating this. They did that before they were my clients, without consulting me, just to be clear. But it's something you can mess up really easy. And finally, big mistake, you need a startup lawyer if you're doing startups. You are fortunate to be here. This is maybe the only reason any of you should be in California is because of the lawyers and the oranges. Those two things, that's it. Those are the two best things. But seriously, here in Silicon Valley, there are a lot of really good lawyers who know startup law. You get not too far out of this valley, you lose that expertise really quickly. Be careful about that. And it goes both ways. You'll find people that, try DUIs for a living and don't really have background in startups. And there's nothing wrong with that, but they shouldn't be doing startup law. Or you find people who do billion-dollar bond deals and they can figure out a startup. It'll just cost you a couple $100,000 in legal fees to incorporate. It's those two extremes. That's a mistake I see, not so often, but every once in a while. And really, it'll stop your company. It'll stop your companies. I have seen companies that failed because of the legal bill they ran up before they ever got to a financing. So be careful about that. Okay, Rob, are we about ready?
All right. Let's hear it for Roger. Applause. So we would like to take as many questions as possible. Roger will be very thorough, and he's not billing, so take advantage of the opportunity.
Wait, I'm not.
No, that's what you told me in the email. So use this for the video. Thank you. Go for it.
Hi, thank you for the presentation. My question is, when you form LLCs, startup LLCs, do you usually choose Delaware LLC, or how do you advise, how to incorporate, where to incorporate?
Good question. Question is what choice of jurisdiction. 99% of the time, I choose Delaware as the state of jurisdiction for corporations or LLCs. And there's lots of reasons for that. With regard to corporations, that's what the VCs are going to insist on. If you plan on going to a VC, you're going to be in Delaware eventually. And there's lots of good reasons for that, good corporate reasons, good practical reasons. But the fact that the investors are going to want you to be there, you might as well start in Delaware. With limited liability companies, that's a little more controversial because California has some good law on limiting, it's called the statute of repose. We have some good law on limiting liabilities that accrue to a California LLC that Delaware doesn't have. But I still pick Delaware more often because I think it's a little easier to convert that to a Delaware corporation down the road. I like dealing with the Delaware Secretary of State's office way more than the California Secretary of State's office. They're slow. They have this thing called peer review, so they don't have to accept your documents if they don't like where the commas are. And their website is old and clunky and bureaucratic. So I have lots, and now the law is a little bit different, just a little bit different between Delaware and California, but Delaware's got this whole body of case law, so you really know what you got with Delaware. For example, you can disclaim fiduciary obligations in a Delaware LLC like you can't believe. So yeah, I'm a big fan of Delaware.
And do you then register foreign entity in California?
Yes. If you're doing business in California, you have to, what they call qualify that company to do business. That means you just file a notice with the Secretary of State's office and tell them you're doing business here, pay them a fee because they're, that's their Nigerian scam. They get a few $100s out of you every year, and then you're authorized to conclude contracts here. Yeah, I'm a little down on California today. I'll be honest with you. This pending bill that our legislature passed just still blows me away. Okay? We'll go here and then there. Okay? Use the mic.
Can I say, is it almost impossible to use independent contractors? For example, somebody sell subscriptions on commission, only commission.
Okay, so here's the thing with employee versus independent contractor. It is so confusing because there are different tests depending which laws we're talking about. So the Dynamax case that I mentioned, what that said is that for purposes of wage and hour, right, wage orders, in fact, meaning everything I said, you got to pay minimum wage, you got to give them meal breaks, rest breaks, etc. For purposes of those laws, a person is your employee if the service they're providing is the same business that is your business. Let me put it that way, right? The service they're providing is a service that your business is providing. So, for example, think of the rideshare companies, right? What are those people doing? They're providing the service to the public of the rideshare company. Under that ruling, they're an employee. Okay, that's for wage and hour. For tax, there's a completely different test. That test is based on 20 factors. That kind of focuses on the right of control. So for that purposes of tax, if the person that's performing the service for you, if they're subject to your direction and control, they're an employee, right? Meaning if you tell them where to sit and when to come to work and use my computer and all this stuff, you keep track, all this stuff that only employees do. So it's very confusing. Workers' comp is a little closer to that test, but not exactly 100% the same. And we have many different rules for many different purposes. So that's one of the big problems here. And most gig economy businesses, they don't fit into any of those categories very well. One judge in the case with one of the rideshare cases before his ruling, he said, well, let me see which round hole I'm going to put this square peg into. They just don't fit very well. So your case, commission salesman, that's a tough one. We see that a lot. And we see a lot of misclassification that way. Because just apply the test. Are they working only for you? Are you their only client, I guess, right? Can you control, where they sell and who they sell to? So I see commission salespeople as contractors and as employees, but that's one that's often misclassified. Okay, we had a question in the back. Use the mic.
Yeah, can you talk a little bit about safes and caps? Because we've got investors that they don't understand safes and they want equity and stuff, and they don't want to close because they don't understand the use of safes and caps.
It's to record.
Okay, the question was to talk a little bit about safes. What's a safe? What's a cap? What's a discount? How do they work? Is it equity? So a safe is a simple agreement for future equity. It's like convertible debt, only it's not debt, it's equity. So under the terms of a safe, this contract, we say, I'm the company, you're the investor. I say, Mr. Investor, I like to call it, the wimpy document. Remember Wimpy from Popeye? Say, I'll gladly repay you on Tuesday if you buy me a hamburger today. So say, give me the money today, right? And we're going to give you stock on Tuesday, or whenever it is that we find an investor in a company that's willing to do a priced round, and we're going to give it to you at a discount to what that investor has to pay. So if the investor has to pay $1 a share, we're going to convert your safe. The money you give me now, we're going to convert that into stock at 80 cents a share. Every 80 cents you gave me gets $1 worth of stock, assuming we do that priced round. Now remember with convertible notes, if you didn't do the priced round, somebody had to repay the 80 cents. It's a note, it's a debt. With the safe, we say, and if we don't do the priced round, we don't get repaid. It just goes away. That's a safe. That's what we're doing. All our seed deals are safes now. Very few convertible debt deals anymore. They're all safes because everybody acknowledges, the investor says, I wasn't looking for a debt return, I was looking for equity return, right? So, and we all know that if you don't do a next round, there's not going to be any money to pay me back. So why go through this charade of pretending there will be? So you ask about a cap. So what he means by that is that every investor's had this experience where they put money into the company when it's worth almost nothing, and they don't take equity because it's just too hard to value. But the company uses their money, and boom, they take off, and all of a sudden they're worth $40 million. And when the investor converts their money, they get one teeny little itsy bitsy piece of this company. If they had put any kind of value at the beginning, they'd have a big chunk of it. So the valuation cap is protection. It's protection from that happening, from a runaway train of valuation. So the valuation cap will say, well, no matter what, when you do your priced round and you do your equity round, my safe is going to convert at no higher a valuation than X. So my $100,000 is going to get at least Y% of this company, at least. That's the valuation cap. Now, the other comment that the questioner asked about is, what about pre-money and post-money? Okay, and I'll tell you why that comes up. Every time I give this talk, somebody asks me that. So one of the early pioneers, I guess, although honestly I've been using this for 20 years, I just didn't call it a safe, but one of the early proponents of this instrument was Y Combinator. And Y Combinator published a safe document online. And a lot of people, who understandably believe that their Google search is as good as my law degree, just went online and they downloaded that document instead of hiring a lawyer, and they signed it and gave it to the investor. And it was okay at the beginning because it was based on pretty simple formula that was pretty company favorable in terms of how you determine the pre-money value, how you determine that valuation. Y Combinator subsequently changed that form and said, we've come up with something a little more fair. But it's not as favorable to the company, it's more favorable to the investor. And what it does, it's how you determine the valuation, what your denominator is. So it basically is a difference in how you calculate whether somebody's getting a percentage of the company before the new money comes in or a percentage of the company after the new money comes in. And you get different percentages depending on how you do it. So be careful. I do not like the new Y Combinator form. I like the old form. Like all my safes are based on the old formula, not the new one. If we had more time on a whiteboard, I'd give you some mathematical examples, but that is something I spend quite a bit of time on here in my presentation called Startup Basics. All right? Okay, any other questions?
Thanks for your presentation. And my question is as following. Let's say I'm a Delaware LLC, registered foreign entity in California, and I sell and ship physical product plus service to all different parts of United States. Do I need to collect sales tax?
Well, you guys did your homework, didn't you? It's like you went out and Googled top current issues in startups before you came here. So the states have always been pretty aggressive, but they've been limited by a very sensible U.S. Supreme Court decision involving my home state of North Dakota. It's called Quill versus North Dakota. It came down in 1989, which put limits on the rights of states to tax out-of-state companies. Say it's just not fair for you to be taxing this California company because they have one remote buyer who found me on the internet out in Alabama or someplace. In that case, it was I don't remember where Quill was located, but they were selling into North Dakota. So that was a very sensible decision. It gave you a little bit of protection, so it limited what the states can do. Constitutional limitation. So a couple years ago, my sister state, the weaker sister, by the way, South Dakota, had another case, Wayfair versus South Dakota. Where, you know Wayfair? I get their catalogs. You know, they're a remote seller, catalog seller. And Wayfair came completely reversed Quill now. I shouldn't say completely reversed, but changed it so that now states have much more expanded jurisdiction to tax. In other words, they can tax if you are actually selling to customers in that state and you're using these instrumentalities, provided that some other conditions are met. So in South Dakota, the condition were, well, you had to sell a certain amount of product into a state. I think it's $100,000 in that case. So now all these states are putting in place these what they call economic nexus standards. So if you're selling into a state and you have enough business in that state, yeah, they're going to start imposing taxes on you. So this is a really big issue because I do a lot of M&A, and in due diligence, we're always looking, you know, the buyers are always looking for ways to lower the price. And so they're looking for mistakes, they're looking for problems, they're looking for liabilities. This is one that always gets screwed up. Companies always mess this up. They've got an employee in a state, they've got an agent in a state, they got property in a state. That's nexus. That means the state can impose tax on them. And now they have sales, they have revenue, they have customers in a state. Well, now they can also impose income tax on you because you're doing business there. So you have to be really careful if you've got customers in other states. What I would do if I were you, the easy thing to do is you got a customer in a state, go online. Every state tax department has a little questionnaire. Go through it. See if you go through the questionnaire. See if you've got enough contacts there where you might have a problem. If you do, just register. Just register in that state. Just bite the bullet, register. You know, collect the sales tax. Don't let them come calling on you. By the way, it's a big deal. Here, why is it such a big deal if you screw up on sales tax? Why is that such a big hassle? I'll tell you why. Let's think of the economics of this, because I had this happen to one of my clients last summer. They do business in a state. They have a margin of about 3%, right? So they sell, it's actually a service, but they sell for about 3% more than their cost, and they do a lot of volume all over the country. They have no contacts in New York City, none at all. New York cannot collect a sales tax on them, except they sent a couple people out there for a trade show. Next thing you know, we got a letter from New York State. Said you owe a sales tax on all of your sales into this state. That means every customer in New York that bought your product, and the sales tax is 8%. Well, let's do the math. My margin is 3%, the tax is 8%. I guess we need more volume because otherwise we're going to lose money, right? So I don't know. It could be a disaster. It could be a real disaster. So the answer technically is, well, yeah, but you just collected. The sales tax is imposed on you, but you have a right. You just collected. It's imposed on the customer. So you could go back to all of your customers and say, hey, you know what? I got to collect sales tax from you. Okay, how likely is that, right? So sales tax is a big disaster. Yeah, you got to be careful about that.
When you said register in that company, did you mean like for an entity or just register for the sales tax thing?
It's just the latter. Thank you for distinguishing that. People mess this up too. Remember I said you have to qualify to do business in California if you're doing business here? Every state's like this. That's with the Secretary of State. That just gives you the right to do business here. It gives you the right to sign contracts and enforce contracts. Then there's registration with the tax authority, right? That's something you have to do in order to do business. You have to get into the tax system. Right? It doesn't give you any rights. It gives the state the right to tax you, basically. So it's a big difference between those two. And there's two different agencies.
Thank you.
Yep.
So you were saying about ignoring the labor laws, and most of CEOs and founders, of course, do not take their salary, as you said.
Yeah.
Somebody tries to defer the compensation. California EDD requirements. So what can you tell us about that? How often do you see EDD coming after the founders on the later stages, or for not taking salary?
Let me get on my high horse again and talk about another agency we love to hate. It's the EDD. But first of all, the rule is, so here's the thing with founders. Remember I said everyone's got to get minimum wage and all that stuff. You got to take meal breaks, etc. So there's an exception to that rule for founders, right? And partners. Basically, it's the partner exception. Like if your partner's in a partnership, you know, the federal labor laws do not require you to comply with all these minimum wage rules. Very sensible rule, right? Founders are like partners. You shouldn't have to pay yourself a salary. It's your business, for Christ's sake, right? As you might expect, California does not have that sensible rule. So you're okay federally, but technically in California, founders are entitled to all of these protections, or they can sue themselves, I guess, their own company for violating them. Now, this only comes up, if you think about it, what founder is going to sue their own company, right? You're not going to do that. So it just never comes up, really, in terms of an action. It only comes up is when you have a bad parting and you have to kick a founder out. And then they'll come back and say, well, you owe me, you know, past due wages, etc. And even then, it's kind of rarely, because then it's only for state purposes. So it's a relatively small number. Okay, now, that's as between private litigants. Now, once the state gets involved, you know, everything changes. Suppose you mess up on, and not just founders, but let's say that you don't withhold taxes on somebody. Let's say you have a rural employee and you just don't withhold, or you misclassify somebody, and you should have withheld and paid taxes, but you don't. The IRS will, you know, they can come after you, but the EDD will as well, and that's California's, was it Economic Development Department or something? What somebody said?
The labor board.
It's a labor board. It's yeah, Economic Development Department or employee, something like that. But they enforce payroll tax claims. And the way they look at it is that money belongs to us. That money is trust fund money. The money you should have withheld, you shouldn't have paid it to the employee. You should have held it back and you should have given it to us. So we're coming after you, company, for failing to do that. Not only that, we're going to come after the owners of the company individually for messing that up. So it can get pretty ugly pretty fast. And this is why here's my objection. The IRS is the same rule, but the IRS has a lot of procedural protections. It's what they call due process rights. You can get a due process hearing with the IRS. You know, you can actually get in front of a live person and examine whether it's really fair, you know, to go after, you know, somebody in the company who might not have been a responsible person. EDD doesn't have all those protections. You just get some agent out there who just decides who they're going to go levy on. And one day you get a notice of levy and you got to hire me to go into court and, you know, and fight it. So this is a tough state on that issue. That's one we really have to be careful about. You know, I hate to be so negative. I'm like Debbie Downer here, but right, this is top legal mistakes, right? It's not top legal successes.
In California, the company
Microphone.
the company's presumed at fault and has to prove it, rather than the other way around. The labor.
Well, I wouldn't. Okay, so the question is in California, is the company presumed guilty until proven innocent? I wouldn't quite phrase it like that, but here's the legal standard. The tax authority's determination is presumptively correct. Okay, whenever you deal with the tax authority, we have a voluntary compliance system. You're supposed to tell them, you know, what your tax is. Their determination is presumptively correct. Right? That means you have to prove that they're wrong. That's right. Yes, ma'am. The lady in the middle, I don't think we've heard from her yet tonight.
Good question.
You like this because it's tax related.
Oh, okay,
so
good.
my question is, so for example, if we have been working on the bootstrapping our company like for 5 years, investing tens of thousands of dollars, and now we're ready to launch, we're registering LLC, we start selling, we're making money. How do we do all those write-offs that we spent before we were incorporated?
How do you do the write-offs? How you get the deduction?
Yes.
Okay.
If we weren't incorporated and then we became incorporated and started earning money. So those were our private kind of...
Yeah, yeah. All right, you ready for this? Yeah, you should be shaking your head. This is okay. So with a pass-through, so the bottom line is you're not going to get the write-offs. I'm just going to warn you, except to the extent the money came out of your own pocket. If it came out of your own pocket, you put it into the company spent it, got a deduction, you will get a tax deduction. Okay, that's easy. But what people do, you know, people have this idea, they've heard that you get a pass-through. So if the company has losses, and they're all going to have losses in the first few years, right? Then I get a pass-through, so I deduct it on my return, and I get all that money back that was withheld by my employer on my taxes. That's the scenario. There's 3 reasons that doesn't work. So number one, so you have an LLC. You own, let's say you two own the interest in the LLC. You have a basis in your interest. That's the amount of money you put into the LLC. So if you take if the LLC has losses that exceed your basis, you don't get those extra losses. You get losses to the extent of your tax basis. So that's limitation number one. And your basis is basically going to be the amount of money you put in. There's some exceptions to that I'm going to tell you about in a minute. Number two, there's this thing called passive activity losses. So let's suppose you're a passive investor in that LLC, and you come along and you put real cash in a company. Company spends the cash, generates deductions. You can't take them because you got no basis, right? So we allocate them to the investor. Guess what? The investor can't take them either because there's a rule that says if you have a passive interest in an activity, you don't get to deduct the losses except to the extent you have passive income, which is none. Okay, rule number 3 is called at risk. And unless it's real estate that you're doing, the rule is you don't get losses to the extent, except to the extent that you're actually at economic risk of incurring that cost. And that means that you actually came out of pocket, or you guaranteed a debt, or you're on the debt, or something like that. So there's a million rules that limit how much. So the bottom line of all this, you know, is just assume you're not going to be able to deduct the loss, except to the extent that you actually got some skin in that game, put some money into that company that got lost. And I'll qualify that by saying accountants regularly get this wrong, you know, and they, you know, so you might be taking losses you shouldn't have. I see that come up, but that's the technical rule.
So what should be done to write, or like to do those deductions as?
If you want the deductions,
Yeah.
If it's for the money you put in, then you're okay. You're going to get the deductions. If you want the deductions based on the money someone else put in,
Oh no.
well, that's what most people do. You know, that's what they're trying to do. They're trying to get. That's what tax shelters are, right? You're taking deductions that are funded by somebody else. That's a lot trickier.
Mm-hmm.
You know, that's
Okay.
that's a much more difficult game to play. Yes, sir.
Regarding options, you've already gone over the rule that that even if your company has no history, but that you want to be able to give your employees the incentive, that you have to use a professional valuation.
Yeah.
What sort of formula do these firms use to calculate, and can you have different results depending upon the firm that's doing such a valuation?
Well, the formula is very scientific. It's that. I think they pull those numbers out of the air, actually, for a lot of these companies because they're so early. I don't know, it's a black art to me. I've read a lot of these valuation reports, and I don't know. What you're pointing out, yes, you will get way different numbers. I had a company once where we needed a valuation for option purposes that was really low. We hired a valuation firm, and they came back at like a really low number. And they asked us, what number do you want? We said, well, value the whole company at $100,000. Okay. They came back like a penny a share. But then one of the investors in the company wanted to value it for purposes of a financial transaction, and he hired one of the big 4 accounting firms, not Deloitte, and they came back with a valuation that was 100 times higher. I'm not making that up. No, you go figure, you know. Yeah, go figure, you know.
So what prevents you from simply going to the firm that will give you the number that you want to see?
That's what people do. I mean, that's what we all do. I mean, we just go say, look, this is where we want the number to come out at. And now, what prevents you from doing that is that it's the auditors. Because when you do get to that exit, the valuation has to be credible. And there have to be certain protections in place. In fact, there's got to be, it's like a verification system in that valuation in order for the auditors to accept it. So here's my example. We have a company we form on June 1 of 2018, and on June 1 of 2020 we now have a offer to sell, and we've granted options all along the way. So the auditors are going to look at that, and they're going to say, yeah, you granted them at the right number because you got the valuation like you're supposed to, but the big four I know will only do this if that valuation followed certain strict protocols. Because of the example I just gave you, like people could just pull numbers out of the air. Yeah, Steve.
Yeah, so I had to deal with this a bunch in the last from the client side, and there's actually a lot of stuff that you can base you don't normally think of. So in one case, I know the exit value of companies in a certain application, right?
Yeah.
They were bought for 80 cents a user, right? And
Yeah.
I have so many users,
Yeah.
but my users aren't as well developed, so maybe they're, or in my side, I get clients who ask me how much have they spent on IP?
Yeah.
All right, they've spent $100,000 on IP, boom. Okay, there's a number. Now
Yeah,
you
there's a
might
number.
adjust it a little bit, but there's often a measure of how many dollars have you spent developing it,
Mm-hmm.
and how many. If you're an engineer that should have been making $200,000 a year and you spent a year on it,
Yep.
this is, and what I've tried to do is make sure that, and I don't do it. This is not my area. I'm a patent attorney, right? Is to make sure that it's consistent. Right, you were just talking about, the valuation jumped from month 1 to month 2 by 50 times. That catches the auditor. But as long as you're being consistent, that's what I've dealt with, because I'm totally confused by this.
I am too. I mean,
So how does a startup know what
Use
is
the
the
mic.
right firm to evaluate you?
how does a startup know which firm should do their valuation? You should just ask them. Just say, look, will your valuations be accepted by the Big Four accounting firm auditors? Then the answer should be yes, because they all know. They've either been approved or they haven't been. And if the answer is no, well, then think real hard about it.
So often attorneys will refer to a recommend.
Yeah, we can refer valuation firms. I don't know, I probably shouldn't give a plug here, but I've got my favorite valuation firms that I know about there that I regularly pass along to people. If you get on a commercial cap table management tool, by the way, they have pretty good valuations, they do, and they're dirt cheap. It's dirt cheap. Okay, Rob.
Right, well, let's give it up for Roger. Applause.
Applause.
It's time for the raffle, which you've all been waiting for. So has everyone who wanted to enter the raffle already done so? Your chances look pretty good. All we need is your business card. Okay.
We're raffling off a date with Steve.
We'll have a deluge of entries now.
Yeah, the price
No
is a
one-
business card.
You can't afford him. All right. So, Roger, you want to come on and do the honors?
Okay.
So, no favoritism. Drum roll, please.
Kevin Hacker.
Kevin Hacker.
Is that your real name, Hacker?
Yeah, that's what.
Kevin Hacker, come on down.
Let's hear it for the hacker. You can get
All
a
right.
photo and an autograph with the author a little bit later
I
on.
guess he doesn't want one. Okay.
All right, next one. He's a hacker. He doesn't want to really know him.
Here, I'll mix these up a little bit.
And the second winner is.
Lena Couture.
Come on down.
Oh, there you are.
There we go.
Is
Want
that
a
your
picture
name
with
or the
Roger?
name of the company?
Lina Couture is the name of the company.
Oh,
My
okay.
name is Helena.
Oh, there it is, Helena.
Close enough.
Thank you.
All right.
Gosh, use
And
my
the final
glasses.
winner for tonight is. Now you can actually see.
All right, well, I'm not supposed to see. I'll close my eyes. Okay. It's Bicon Sushanik Kachaturian.
Come on
Of
down.
course.
Well, you had all those questions, so now you can read. You want a picture with.
That's only fair. Thank you. Okay. All
no
right.
picture.
All right.
You want a picture with Roger?
Yeah.
Yeah, go for
Okay.
it.
All right.
All right. So the video will be on our YouTube channel in a couple days, youtube.com/idea-IPO. You want the slides, email Roger directly. So thanks for coming, and we'll see you next time.
If anyone wants my slides, just send me an email.